And welcome back, everyone, to the Oxford Jurisprudence Discussion Group. This is our second seminar of this academic year, 2021 and 2022, and the first seminar that we are hosting online. We have the pleasure today of being joined by Dr. Paolo Sandro. Paolo is currently lecturer in law at the University of Salford, Manchester, and will be presenter a paper titled The Dependence of Constitutional Democracy on the Distinction between Creation and the Application of the Law. This is a draft chapter of his book, The Making of Constitutional Democracy from Creation to Application of Law, to be published later this year by Hart Bloomsbury. Paolo, thank you very much for being here today. The floor is yours.
Thank you so much to the conveners for the invitation. It's a pleasure to be back presenting at the Oxford Jurisprudence Discussion Group. Can you just confirm that you can see the slides? Yeah, perfect. Thank you very much. As it was just mentioned, today I am presenting something from my new book, which is out in less than 2 months now. As you can imagine, I am equally excited and anxious in equal parts at the same time, because this is pretty much my main work, what I've been working for the most part of the last 10 years. And this is the first time I'm actually presenting it out in the wild. Now, the book, I'm not gonna say much on the book in the presentation, more than happy to say something in the Q&A, but the book has two overall meta-theoretical aims or objectives. The first one is trying to contribute to bridging the gap between jurisprudence, public law, and other disciplines, for instance, history, political science, anthropology, and this is done through what I called a integrated jurisprudential methodology. Again, more than happy to discuss this further in the Q&A. The second overall meta-theoretical objective of the book is trying to bridge a gap that I've noticed very soon after starting my PhD in legal theory at the University of Edinburgh 10 years ago, more than 10 years ago now, which is a certain gap or a certain lack of engagement between Anglo-American and Romance language scholarship, particularly in jurisprudence. And that's why the book has a very extensive citation apparatus, as you might have noticed if you looked at the chapter that was shared. Now, I've decided for today, because I could not go in 30 minutes throughout, the entire of the chapter is quite long. So I've decided to focus on two specific and possibly the two most contentious arguments or theses that I put forward in the chapter. Now, the overall aim of the chapter is to illustrate how democracy, and particularly constitutional democracy, is premised on the possibility of distinguishing between the activities of creation and application of law. Why would there be even such a need? Well, because once legal theorists look at the distinction between creation and application of law, the vast majority of them, and in particular, legal realists, critical legal scholars, legal constructivists, even Dworkinians, they in different way reject the idea of law application, again, in different forms, or at least say that law application is not really what we presuppose what most legal positivists or other more traditional approaches to law presuppose. So what I'm going to do today is I'm going to introduce two basic and contentious theses that I put forward in the chapter. The first one is my account of constitutionalism as legal otherness. And the second one is what I see the consequences of my account for political constitutionalism. Let's start with the first one. Now, I'm not saying anything new here, because I am basically just quoting, among other people, Habermas. Habermas, in a famous article, has described or inquired whether constitutional democracy is the paradoxical union of contradictory principle. The contradiction or the tension would be between the principle of democracy on the one hand, the idea of self-rule by the people, the idea of political equality, vis-a-vis the idea of constitutionalism as the imposition of limits, and particularly legal limits, on the power of the political authority. So constitutionalism has the idea of limited government, and particularly limited government by law. The paradox is, once we realize that if we are asking government, political authority to be limited by law, how is this possible if law is itself the creation of government? And again, this is not perhaps a real paradox, but has been described in some cases as a paradox. And what was the solution that has been found in terms of constitutional design over the years, and particularly in the last 100 years or so, certainly after the Second World War? Well, the most famous solution is the one that is exemplified by the liberal revolutions of the 18th century, the American, the French, and the idea of putting a different type of law, a superior type of law, above ordinary legislation, written entrenched constitutions. Here you can see a picture of the US federal constitution. So the paradox that I was just talking about, how can government be legally limited if law is the creation of government, is resolved, so to speak, by the creation of a different type of law that sits above the power of the political authority, and that at the same time legitimates legitimates and limits political authority, and particularly the power of legislatures. Now, again, this model, the idea of the model of entrenched constitutionalism, or legal constitutionalism, as it is sometimes also called, has become very clearly the most widespread, particularly after the two world wars. Nowadays, we know that most constitutions around the world have an entrenched constitution, and almost all of them also give a court or courts the capacity to enforce the Constitution vis-a-vis ordinary legislation. What I see, though, and what my studies in the last 10 years have kind of indicated to me, is that in much of contemporary constitutional theory, there is an unwarranted equation. And particularly, I mean, the equation between the realization of the doctrine of constitutionalism, again, the idea of limited government by law, and this is usually, or most of the time, implicitly, sometimes explicitly in other times, equated to the presence of a codified entrenched constitution in a given system. So realization of constitutionalism, presence of a constitution in the system. And to me, this has two negative implications, two problematic implications for constitutional theory. The first one is the following: that if a state has a codified constitution, regardless to some extent of its contents, there is a prima facie case for that state to be considered a constitutional one. And we can see this, there are several historical examples even nowadays of countries that have entrenched constitutions that perhaps pay lip service to the idea of constitutionalism, to the idea of limited government, but the reality is that they don't really realize or pursue the doctrine of constitutionalism. But then there is a second implication, and I think this is even more interesting. And this, to me, I've called it in another publication. I've called it a quasi-paradox. Most people, most constitutional and political theorists, really. For instance, Giovanni Sartori wrote about this already in the 60s, but many people after that, or even before that. Many people consider Great Britain as the birthplace of modern constitutionalism, of the idea of limited government. And particularly, we can talk about the Magna Carta, but you know, the general, there is a, I don't want to call it a consensus, but almost a consensus. There is a clear idea that Great Britain is, in some respects, the birthplace of modern constitutionalism. The problem, of course, is that Great Britain doesn't have a codified constitution. So how can this be? How can this be that Great Britain is the birthplace of modern constitutionalism if there is no codified constitution? To me, the issue lies in the fact that again, there is this equation between constitutionalism, the pursuit of limited government by law, and the presence or lack thereof of a constitution. So in the chapter, what I try to show is that constitutionalism does not necessarily require the presence of a codified, entrenched constitution. That is not what constitutionalism requires at a minimum. What constitutionalism requires is the limitation of law by law. But how could you have that? Let's go back to the paradox that we started from. How could you have the limitation of law by law if there is no constitution, there is a hierarchically superior to the ordinary legislation of the political authority? This is where I think, and my experience in this sense has been pretty amazing, because when I moved to the UK, of course, I had some knowledge of the UK model I had some knowledge of the common law, I have some knowledge of the UK model of constitutionalism, but not enough. And the more I would look into the model, the UK model of constitutionalism, the common law model, and the more I realized that actually there was a different configuration, a different institutional settlement through which constitutionalism could be pursued. I share here the cover of one of my favorite books. This is a short book by, I think it's a Belgian scholar, Professor van Kynegem, who wrote a very beautiful introduction on the birth of the English common law. And this is a book that I really enjoyed. And through an historical and conceptual exploration and analysis, in the book, I try to show that what happened in Great Britain is that an institutional setting developed over centuries in which law as the product of political authority, lex, is limited pragmatically by a different type of law, the common law, use. Now, the use of these two Latin names, lex and use, is not accidental, of course, because there is a number of very, I think, really fascinating historical books, legal history books written recently that have, to some extent, showed how this idea of constitutionalism, this duality of law and the limitation of lex as the product of political authority by a different type of law, use as developed by courts, by legal professional, started in the late Roman Republic. And I'm talking in particular about the book Crisis and Constitutionalism by Benjamin Straumann. And at the same time, there is another legal history book that I strongly recommend to everyone, which is Thomas McSweeney, Priests of the Law. And in this book, Thomas basically shows how the first judges of the common law, the first members of the King's Bench, they drew on the understanding, on the self-reflexing understanding of Roman lawyers. They didn't draw on the specific institutions of Roman law. That's why the common law developed so differently from the rest of the continent. But they drew on their idea as jurisprudence. They drew on the idea of law that we're developing. And I think Tom makes a really compelling case in the book. The key feature then is that this different type of law use is, at least in its core principles, independent from the will of the political sovereign. And we see this right now in the law of the judicial review, and in the fact that the basic principles of judicial review are developed, are the purview of the courts and not of parliaments, have been developed by the courts. Now, I'm very happy to go more in detail in the Q&A if everyone would like that, particularly as to what I mean that this limitation is done pragmatically. What I would like to mention now, just to conclude on this topic, is that clearly, and more than in the legal constitutional model, in the entrenched model, in the common law model of constitutionalism, the working capacity of the system, the feasibility of the system is premised on the mutual trust and respect among constitutional actors, which is exemplified in the observance of constitutional conventions. Clearly, in this setting, in this institutional setting, more than in the other one, they're important as well, but in this, they are fundamental to the viability of the system. So just to conclude here, what I try to show in the book is that constitutional democracy, despite what the legal constitutionalism and the political constitutionalist camp basically put forward, constitutional democracies share the same structure, and they're premised on this duality of law. On the one hand, you have law as lex, law as the form and the product of political decision-making. Clearly, in democratic system, this represents the self-rule of the people, either directly through referendum or indirectly through the election of representatives, and it is legitimated as such. And then you have a different type of law, use, that is based on past and current norms or aspirations of positive morality in the social group, justice, and I'm more than happy to discuss the way in which lex and use, in my view, relate differently to the idea of justice. Now, what it's important to recognize is that this different type of law use can be either entrenched in a formal document that sits hierarchically above ordinary legislation, or it can be pragmatically enforced by court through an institutional settlement that is buttressed by the convention, as it happens in the common law model of constitutionalism. Now, if I'm right about this, or if at least I've made a prima facie case to try and see that constitutional democracies of all kinds share this basic dualist structure and this duality of law between lex and use, I see this as eliciting some problems for political constitutionalism. And I will speak in the next 10 minutes or so about two problems in particular. Now, the first problem is the following. Given that very often political constitutionalists, they draw or they present the British tradition, particularly after the enactment of the Human Rights Act in 1998, particularly before that, they present the British model of constitutionalism as the best example in history of political constitutionalism. I fear that they either misunderstand or misrepresent what the common law model of constitutionalism is really about. The limitation on the power of parliament to make laws in the common law model of constitutionalism doesn't come from the political constitution, or how I like to call it, the invisible hand theory of constitutionalism. Invisible hand because, of course, it reminds me of Adam Smith's theory, economic theory of the invisible hand. In the same vein, for political constitutionalism, we don't need really legal constraints on the power of parliament, because political processes are enough to make sure that parliament doesn't go beyond what is supposed to be its remit, or beyond what is legitimate in this respect. There is also a more terminological point to me that if your theory does not put forward, does not contain the idea of legal limits on legislative authority, then it's not really constitutionalism. But this is more of a definitional matter, but I still like to point it out. To me, and here I know that I'm saying something very contentious, but to me, the category of the political constitution is unhelpful from a conceptual point of view. To me, either there is a codified, entrenched constitution, well, it doesn't need to be entrenched, but a codified formal document that needs not be called a constitution, but needs to perform the functions of a constitution, and particularly the legal limitation of government, or you don't have a constitution. But again, that's not a problem, because it's fine. The common law model of constitutionalism does not need a constitution. And to me, actually, the insistence of this category of the political constitution is another byproduct of that equation, of that unwarranted equation that I was mentioning before. At best, in my view, the emphasis of political constitutionalism is an important one, and it's on the relevance of political conventions for the sustainability of the common law model of constitutionalism. So I want to be very clear about this. By no means I think, or I say in the book, that politics are not important. On the contrary, formal rules in a constitution that don't have support or are not supported by existing current political practices are pretty useless. And to be honest, I don't think any legal constitutionalist would deny that. I also have no problems with political constitutionalism as a purely normative theory, as the idea that we are better off without legal constraints on the power of the highest legislative authority in the polity to make laws. My problem is when political constitutionalism is presented as an historical conceptual elaboration upon the British tradition, or when the British tradition, it is said that the British tradition exemplifies political constitutionalism. In my view, it does not. Now, second problem. And I'm gonna finish with the second problem. So I will be done in about 5 to 6 minutes. Now, remember what I said at the beginning, hopefully. I know it's quite late, and again, I apologize about that. But at the beginning, I said that the overall aim of the chapter is to illustrate the which constitutional democracy as an institutional normative practice is based on the possibility of application of law. Basically, if there is no law application, then we can't really see that we live in constitutional democracy. Our political, institutional, normative practices are basically traps, or they're not really legitimated in the way we think they are. And so let me show you what I think is another issue for political constitutionalism that my analysis, if correct, elicits. And I think this one cuts even deeper than the other one for political constitutionalists, because it shows a contradiction in political constitutionalist theories. Now, I'm taking this passage. This is, some of you might have recognized it already. This is from Jeremy Waldron's. This is taken in particularly from the court case against judicial review, but this passage is so central to Jeremy Waldron's attack on judicial review of legislation that is repeated verbatim in at least 2 other publications, in a right-based critique of constitutional rights, 1993, and in Law and Disagreement. And I'm drawing your attention in particular to the middle statement. Waldron writes, one lesson of American constitutional experience is that the words of each provision of the Constitution of the US Federal Constitution tend to take on a life of their own, becoming the obsessive catchphrase for expressing everything one might want to say about the right in question. Now, Waldron is explicit about this argument, but I submit that you can find this argument in a more implicit way in most political constitutionalists. I think this is also part of the argument, part of the attack by Bellamy in chapter 2 of his famous book, and other political constitutionalists share this kind of indeterminacy argument. The argument basically saying that because constitutions are indeterminate, then what judges really do is not really applying the law, is not applying the constitution, but basically using the constitution as an excuse to say whatever they want to say. And of course, this is problematic. Now, what they basically do is political constitutionalists then draw a implicitly qualitative distinction. They draw implicitly a qualitative distinction between ordinary and constitutional adjudication, whereby only the former is able to yield determinate outcomes on the basis of the applications of the norms contained in legislation. In other words, whereas judicial adjudication is legitimated for political constitutionalists vis-a-vis ordinary legislation, because there are such things and rules that can be applied by courts, this is not the case for constitutional adjudication because of the indeterminacy of the constitutional text. Now, the interesting thing is that I think in the court case, Waldron in a footnote even says that someone pointed to him about the dangers of this line of argument for his theory, but he literally says in the footnote, I'm not going to explore this further. But let's try to explore this further, actually. The problem for Waldron and other political constitutionalists is that their accounts, their theories of democracy, their theories of what it means to live in a political constitutional democracy, if you pass me the term, their accounts are squarely based on the idea of applications of norms. So This is problematic because we know by now that constitutional and ordinary legislative norms are much more alike than what political constitutionalists are willing to recognize, especially nowadays. The problem with Waldron arguments and with the arguments of many other political constitutionalists is that they always tend to take the US federal constitution as the paradigmatic example of legal constitutionalism. And that is problematic. The US Constitution is older than most other constitutions around the world. It's much more difficult to change. The text is more indeterminate than other constitutions. And this is not something that I'm just saying. There is beautiful empirical research done, for instance, by Mila Versteg and Zakin in 2016, in which they show that recent constitutions are more precise in the language and easier to change than the US federal one. In other words, most of the recent constitutional texts around the world are way more similar to ordinary legislation. That, by the way, ordinary legislation is plagued by the same issues of vagueness, of indeterminacy, of open texture sometimes, than constitutional text. So I think that on the one hand, political constitutionalists here, they commit a one-theory-fits-all fallacy. Because I have no problem in saying that their argument is correct vis-a-vis the US federal constitution. I fully agree with that. I don't think that the US federal constitutional system is the best example that we can have of a entrenched constitution and one that can actually manage somehow the tension between the democratic principle, political equality, and the protection of rights and the application of rules. So on the one hand, there is this one theory fits all fallacy. But I think there is something even worse for political constitutionalism, and I think they end up in a conundrum, and I'm going to conclude on this. What is the conundrum? As long as political constitutionalists maintain an untenable theoretical distinction between the judicial application of constitutional and ordinary norms, what they're actually doing, they're implicitly undermining two fundamental elements of their own theories. Democracy, because democracy is based on the idea of applications of rules. Otherwise, how can we say that people are ruling themselves through democratic procedures, either direct or indirect ones? And the rule of law, which again is at the core of Bellamy's, of Waldron's accounts of states, of democracies, but it is based on the idea of application of law. So if political constitutionalists maintain this line of attack, then actually they're undermining their own theories, because there is no qualitative difference between ordinary and constitutional norms or constitutional text. Again, if we exclude the example of the US federal constitution. But if, and this is why it is a conundrum, if they were instead to acknowledge that the difference between the application of constitutional and ordinary legislative norms is not in quality, but at most in degree, and thus changes from system to system, then I think that this key tenet of their argument against legal constitutionalism, against the idea of judicial supremacy in constitutional interpretation, loses most of its bite. It cannot be, it's not a theoretical argument anymore. It's only an empirical argument, which is great. I think it's correct, but it only applies to some systems and not others. So I think this is this objection to political constitutionalism cuts even deeper than the first one. And I do really believe, I might be wrong, but I really do believe that it puts political constitutionalism in a conundrum from which I'm not sure how they want to get out. So thank you so much for your attention. Again, apologies about the late start. I've been teaching 6 hours today, so I'm really grateful for your attention and looking forward to any question you might have. Thank you very much.